Jane, I notice it's 3:30. Should I
Yes,
get it
it's
started?
3:30. Yes, let's get started. So
All
welcome
right.
to International Law Week. There are 60 participants now.
Welcome. All right. So I'm Peter Margulies, and I want to first make sure that everyone has CLE information for this event. And so I'm going to just share my screen now for CLE. This is your code for CLE if you signed up for that. I know that's very important for many people at 637185. Okay. So I'm delighted to be the moderator of our panel today on privacy, surveillance, and human rights. And we have a great panel for you today with people who really know this area backwards and forwards. So I'm Professor Roger Williams, University School of Law in Rhode Island, USA. I just posted a paper to the Privacy and Civil Liberties Oversight Board website on a statute I'll talk about today, which is the Foreign Intelligence Surveillance Act. Our panelists include Els de Buser, who's at Leiden University at the Institute of Security and Global Affairs in the Netherlands, Brian Egan of Steptoe and Johnson, formerly legal advisor for the US Department of State, Margaret Hu, who's now at Penn State University School of Law, and is, in addition to being a professor and a noted privacy scholar, the dean at Penn State for Foreign Programs. And then we have Becky Richards, who is at the U.S. National Security Agency, the NSA, and is the Civil Liberties and Privacy Director at NSA. And last but definitely not least, Patrick Toomey of the American Civil Liberties Union, who argued the Hasbajrami case on Section 702 of FISA, which we'll discuss in the course of this panel. Let me share my screen again, and I'll quickly go through my slides on surveillance. So here's my slideshow. Let me see. Actually, I'm gonna. So I'll talk a little bit about surveillance in connection with first traditional FISA and then 702. So traditional FISA is a statute that started in 1978. And what it does is say that the government can get a court order to check on communications of someone who is an agent of a foreign power. There's probable cause to believe someone is an agent of a foreign power. And FISA also set up what's called the FISC, the Foreign Intelligence Surveillance Court, that awards those orders. So FISA has been used in that capacity since 1978. One thing you may know, which is important, is that it's been the subject of controversy in the past several years, particularly from a particular FISA request in 2016. That was the FISA request for Carter Page, who was an advisor to then candidate Donald Trump in the 2016 election campaign. The government sought and obtained a FISA request on Mr. Page on the ground that he was an agent of a foreign power, in that case, Russia, based on allegations that Page was a familiar of senior Russian intelligence officials. It turned out, though, based on a report by the U.S. Department of Justice Inspector General, that that request did not also indicate to the court that Page had been a contact for a U.S. intelligence agency, believed to be the CIA, which might have had a fundamentally different cast to the allegations against him. That information was omitted. The Justice Department has now acknowledged that that should have been provided, and the FISC has indicated that it would have been a very good idea to provide it as well. On top of that, Page had denied in interviews with an FBI confidential human source that he knew these senior Russian intelligence officials. He didn't even know of at least one of them. And that information also did not find its way into the FISA request for Page, who's never been charged with a crime. In addition to FISA, to the traditional FISA, we also have 702, which is a post 9/11 development. And 702 is notable because it doesn't require a court order. Instead, it provides for annual approvals of certifications by the government that involve the targeting of foreign identifiers, typically email addresses or the like, of people abroad. Under 702, the government can, amongst other things, look at so-called one-end foreign communications. That is, communications in which someone abroad is either the sender or recipient of communication that also involves a US person, that is a citizen or lawful resident of the United States, or someone who is currently physically located in the United States. The FBI and the NSA have on occasion used what are called US person queries. That's questions, it could be search terms or the like, to search the vast database of Section 702 information. And in a case called US versus Hazbajrami, that Patrick and others will talk about, the Second Circuit, in an opinion in 2019 by my old con law professor, Jerry Lynch, decided that that kind of US person query of the vast trove of 702 information constituted a search under the Fourth Amendment and therefore had to be reasonable. And the question now is, before the district court in that case, are there adequate safeguards to make that kind of US person query search a reasonable one for purposes of the US Constitution? So that's brief background on US surveillance that's relevant here. I now want to turn this over to Els, who's going to talk about issues regarding EU privacy law. Els, take it away.
Thank you, Peter, for that introduction. Indeed, and thank you for inviting me again. It's always nice to give the EU point of view. So the biggest development in surveillance and in data transfers between the EU and the US is, of course, the Schrems II case. You may have heard of the Schrems II case, which was ruled upon in July, about mid-July this year, which meant that for the second time, I'll try to make a very long story very short for the sake of time constraints. For the second time in about 5 years, the EU Court of Justice struck down the arrangement, the agreement between the EU and the US on data transfers. For reasons of, one is bulk gathering, the sort of mass gathering of data happening in the US according to the Court of Justice, and secondly, the lack of administrative and judicial redress in the US for EU citizens. So to give a little bit of context of where this comes from, because you may have heard of the name of the arrangement being called the Privacy Shield, which was already the successor of Safe Harbor, which was struck down in the Schrems I case a few years ago. So the Privacy Shield was in fact a set of commitments, an arrangement between EU and US authorities on how the US could could have an adequate level of data protection. And that standard, the adequate level of data protection, is a standard that the EU introduced already in 1995, in fact, with the goal of avoiding data laundering. That's how I always call it. Data laundering, meaning the EU wanted to avoid having its rather high standards of data protection being, let's say, escaped by exporting data out of the EU and then re-importing them back into the EU. That was actually the background of this standard of an adequate level of data protection that every third state receiving data from the EU should have. If that adequate level of data protection was not there in the third state, that third state would not be allowed to receive data from the EU. So first attempt at making this agreement between the EU and the US failed, was struck down a few years ago. The second attempt was struck down as well, for more or less the same reasons. Now, The big question is what is now going to happen? What are the consequences? Because when the Court of Justice took down the legal basis of these data transfers, we all know that the data transfers are a big part of economy and also a big part of security, national foreign security and criminal investigation. So what is now the plan? So first of all, the fact that a privacy shield has been declared invalid has not meant, and the court was quite clear in that the alternative tool, alternative to a wider agreement between the EU and US, called the standard contractual clauses, meaning on a smaller scale for a specific data transfer in a contract, you create a provision that offers appropriate safeguards. So again, the idea of the adequate protection of data traveling with the data is now put in a contract. So the tool is still valid, the legal basis is just not. And that has complicated things a little bit because the Court of Justice has in its ruling said that although the tool is still valid, the European Commission, representing the interests of the EU, is not obliged to give that rubber stamp on a level of data protection in another country, in this case, the US. The European Commission is not obliged to do that. So they are basically shifting the burden onto the data controller. They're shifting the burden onto a company. A company is put in the driver's seat. A company is put in the position of assessing, evaluating the level of data protection of a third state. Personally, I think this is not a good idea, although it is a shift that we've seen in other dossiers as well, in the digital evidence proposals that are still going through European Parliament at the moment. That was also the basic idea. Put the burden on a company to assess the level of data protection in a third state. First of all, companies have different interests than governments. Secondly, I think companies are not equipped to do this. SMEs especially, who are already under large financial stress at the moment in the pandemic, will have to make significant investments and enlarge their legal department, for example, or outsource this. And thirdly, what you will end up with is a patchwork approach. You will end up with very different approaches. Whereas if the European Commission would be in this position on rubber stamping the level of data protection in a third state, you would have one harmonized decision. So that is my take on the standard contractual clauses and the burden put on companies. And then a last point I want to make, the first reaction we saw on the market, and then I mean data controls, but also among data protection authorities, was, well, if the court has now struck down the legal basis of the transfers, then the only option is do not transfer, which translates as data localization. So instead of transferring the data, let's just keep them all within our own territory. And this has been a bit of a panic reaction, also creating a patchwork approach because, for example, the region of Berlin, the Data Protection Authority of Berlin has said, well, we want every data controller to keep the data in their own territory, do not longer transfer. Whereas every other region in Germany had a different approach. Some were with Berlin and some were not. So even within one country, there was not one approach. And this is what I will end with. With data localization, you have to be aware that there are significant technical arguments against it, meaning it starts from the premise that there's only one location for data, which is not how the internet works, of course. Data are mirrored, data are copied, data are cut up in chunks and are spread over servers to ensure their performance. And when you would go for the approach of data localization, it also means that your cybersecurity costs are going to raise because you're going to bring the data to your own territory and have to store them in a secure way. Bringing me to my last point, and that is the economic argument against data localization. Again, putting quite a financial burden on companies to take this kind of approach. I will leave it at here right now for the sake of time constraints and look forward to the discussion.
So Els, I would be remiss if I didn't also ask you a little bit about the General Data Protection Regulation, the so-called GDPR. And I'm particularly interested in the right to an explanation under the GDPR. Could you explain the right to an explanation?
Yes, so when the EU institutions were drafting the General Data Protection Regulation, the new data protection legal framework that all the EU member states have to comply with, a new right was written into the text, giving data subjects, so citizens, the right to request the logic behind an algorithm from whoever company, whoever wrote and was exploiting the algorithm. So an algorithm in itself is already technically high level science, I would say. But explaining the logic of an algorithm to any layperson, I think is first of all extremely complicated. But I think the second problem that I see with this right, even though the idea of the right is quite a good one, the problem that I foresee is that companies will not want to give away their trade secrets, their business model, which will be built into the algorithm. So they will probably, this is my I think the most likely route to take is that companies are going to rely on very general statements, which will then hollow out the whole right in the first place. When you look at algorithms as such, you can take it one step further and say, how is this going to play out when we're talking about artificial intelligence or machine learning, where systems are improving an algorithm as they go, and the transparency will be quite a big question mark here. So I think this is a very underdeveloped field still, explainability of AI. I think this is the new field of research that I see many PhD students now digging into. So I think the coming year, since the title of this panel is also Outlook for 2021, I think this is going to be on the agenda in many places.
Els, that's really terrific. So I now want to talk a little bit more about the issue of algorithms that you mentioned, and I'll open this up to the entire panel, particularly with reference to Brian. We talked about algorithms. The US has been in the forefront regarding development of proprietary algorithms. We sometimes talk, for example, about the United States of Google, right? Given the search algorithms that Google has pioneered. Of course, Google's now the subject of an antitrust suit brought by the US Department of Justice. In addition, the US has been a pioneer in developing other kinds of advanced technologies, including algorithms that work at facial recognition. And there are issues about export controls, whether the US as a nation state in the traditional sense, as opposed to a corporate state like Google, whether the US can control the licensing and transfer of this kind of technology from the US to other countries and firms. Brian, do you want to weigh in on that a little bit?
Sure. Thanks a lot, Peter. Thanks for everybody for participating. So the issue of regulating the use of facial recognition technology and some other biosurveillance technologies has been a big issue in the United States. Of course, there's a domestic issue here in the United States about US law enforcement using these technologies themselves, which has been highlighted in a lot of the incidences that have been in the news here in the United States this summer and spring, where police forces have committed abuses involving racial minorities. So that's one topic, is what to do about these technologies in the United States, where you have a number of cities which have banned their police forces from using these technologies. You have some probably modest movement in the Congress about regulating these technologies in the US, but that's one piece of what's been going on in the United States. And of course, our tech companies are some of the world's leaders in developing facial recognition technology, which includes the algorithms, Peter, that you just mentioned, that allow, in particular, computers to identify specific faces out of large databases of faces. Some call this the one-to-many technology. So it's not so much if I use my passport presented to somebody to verify who I am. It's more that my passport could be stuck into a large database of millions or thousands of pictures, and that database could be used to surveil me without my consent as I walk through a shopping mall or something like that. That's the most controversial use of biometric facial recognition technology. So no real resolution on the US level. On export controls, as you said, Peter, the Commerce Department, the Bureau of Industry and Security, which regulates commercial export controls from the United States, started a rulemaking over the summer to review whether they should implement new controls in the area of facial recognition technology. And so the theory behind this rulemaking is not so much how these technologies are being used here in the US, of course, but are we selling these technologies abroad to totalitarian states and others who may use these technologies to commit human rights abuses? And it's been an interesting rulemaking. There were a number of comments published, some mostly in favor of some sort of regulation, including by some somewhat unusual bedfellows. So IBM, one of the largest companies in the United States that actually develops facial AI that can be used for facial recognition, actually sent in a letter to the Commerce Department proposing that commerce should regulate these exports in at least some limited areas. IBM says, don't throw out the baby with the bathwater. You don't want to regulate everything, and you've got to think about end uses and end users and what is actually of concern to the US government. But they said, we believe that the US government probably should impose regulations on AI software and technology that can be used in this kind of one-to-many sense, where you have a large database of faces that could be used to identify specific people without their consent. So this rulemaking is still going on. The comment period closed last month. The Commerce Department is, among other things, thinking about changing their rules for which countries could receive these technologies. And so if you are a like-minded country, if you establish rules that are similar to the US on export controls in these areas, you may be more likely to be the recipient of the technology through licenses issued by Commerce. If you don't have controls, or if there are human rights concerns, then you would be less likely to get a license. And I would expect this rulemaking to probably come out with a draft rule at some point over the next few months. I'll stop there for now.
Brian, thank you very much. So let's try to talk a little bit about facial recognition itself. An advanced technology does have the concerns about privacy that Brian outlined. I wondered if Margaret and Patrick could talk a little bit about the privacy concerns behind that technology, particularly under United States law.
Sure. Thank you so much, Peter. And for that generous introduction, I just wanted to clarify that I just started at Penn State, and they gave me the title of Associate Dean of Non-JD Programs. So I do feel like I'm the Dean of a foreign program since it's new and very, very nascent. But so under the Fourth Amendment, I think that it will be very interesting to see what happens with the Supreme Court post Carpenter, a 2018 Fourth Amendment case that recognized cell site location information as protected and requiring a warrant for the law enforcement in order to acquire that data, even though it was held by corporations and therefore seen by some to fall within the court's jurisprudence on the third party doctrine. So under the Katz test and the reasonable expectation of privacy, the argument of the government was that this information is not private. This cell site location information has already been shared with a corporation, and that there is no need, to have that protected. So with facial recognition technology, given that you present your face publicly, you know, do you have any type of reasonable expectation of privacy to, you know, the facial recognition technology? And also, I think there's a question that, you know, Brian brought up, the fact that a lot of facial recognition technology now is being integrated with artificial intelligence. So the ability to aggregate the databases that once upon a time, when the technology was still new, was primarily used for identification and verification purposes. And so matching a face in a database in order to, you know, based on the template, you know, ascertain whether or not there was a match. And that was just straight up biometric identification verification technology. But now, fast forward several decades later, the integration of facial recognition technology with a whole host of other aggregated databases, both public and private, and the ability to do real-time situational awareness surveillance, where you know, it's highly predictive and might be monitoring real-time social media you know, surveillance technologies at the same time, I think raises an entire host of new questions under the Fourth Amendment. And now with a different composition, without RBG and with Kennedy's departure, I think that that was a very close opinion. It was a 5-4 opinion with Chief Justice Roberts authoring it, you know, with 4 separate dissents that were all, you know, very, very forceful on why they did not feel like this was, you know, the cell site location information should fall within the Fourth Amendment's protection. I'm not sure what's going to happen with facial recognition technology. I'd be very interested in hearing what Patrick has, you know, to say.
Patrick?
Thanks, Peter. Thanks, Margaret. And great to be here, everyone. So, you know, I'll just start by echoing what Margaret said. Facial recognition, like a host of other biometric surveillance tools, raises, you know, a wide range of privacy concerns, including Fourth Amendment concerns. You know, Brian talked about this one-to-many matching, which is kind of the most concerning use of this technology, especially when integrated with other systems, because it allows the government or private entities to pervasively identify and track anyone or potentially everyone as they go about their daily lives. One of the cases that's going on now is a case, or a number of cases really, against Clearview AI, which is a company that has essentially created a search engine for facial recognition. It scraped images off the public internet, websites like and services like Facebook and elsewhere, to create a vast database of images that it can now use to match against photos that are submitted by its customers, which include private companies and law enforcement agencies. And the ACLU and others are now bringing a range of different challenges. Some of them relate to Illinois' law, which is kind of at the vanguard of privacy protections in the US. It's Biometric Information Protection Act. But as Margaret said, the contours of a Fourth Amendment argument are also now becoming clearer on the heels of the Carpenter case. And so I think this is an area of the law that is evolving and evolving quickly as the technology advances. The Ninth Circuit had an occasion to consider facial recognition technology in another suit against Facebook for violations of Illinois' biometric law. And even in that decision, the court, while the merits of the kind of Fourth Amendment or privacy question weren't before the court, it nodded to the Carpenter decision as signaling that courts were beginning to recognize that simply because information may be shared with third parties does not mean that there is no privacy interest in it. And these kind of immutable characteristics that are in our faces or our irises, in our DNA, are at the forefront of the issues courts are going to be grappling with going forward.
So Patrick, I want to pick up on that and ask you and Becky a question about the recourse that people who have been the targets of surveillance might have. That was certainly a major concern, as Elle suggested, of the Court of Justice of the European Union in the Schrems case. US law traditionally has given less recourse to targets of surveillance than has been the case in the EU. And Patrick, you mentioned when we talked earlier, the case of Moaleen, the Ninth Circuit case, which talks about notice to targets of surveillance. Can you talk about that a little bit?
Sure. So a little background on the case. The Moaleen case was a challenge in the criminal context to the bulk collection of Americans' phone records under a provision called Section 215 of the Patriot Act. That it's also part of FISA, the statute that Peter described earlier, but is a provision that deals with business records and permits the government to collect those types of records or a broader category of tangible things under a standard that's less than the traditional warrant requirement on the basis of relevance. And the NSA for years was collecting call records in bulk pursuant to that authority. And the program was revealed through the Snowden revelations in 2013. And in its defense of that program, certain officials pointed to Mr. Moaleen's case as one where the program had proven valuable. And on the basis of those disclosures and public statements, Mr. Moaleen challenged the surveillance. And so his case presented a challenge to the bulk collection program and the way in which it fed into his criminal prosecution, but he also sought to challenge other types of surveillance, including surveillance under Executive Order 12333, which he argued the government had used in its investigation of him and his co-defendants, but had not disclosed in the course of the prosecution. And the Ninth Circuit's decision dealt with this issue of when individuals are entitled to notice of foreign intelligence surveillance. And the court held that, that the Fourth Amendment's reasonableness requirement carries a requirement of notice when the government intends to use information obtained or derived, even from foreign intelligence surveillance, in the course of a criminal prosecution. And so to bring this back to where your question started, Peter, the question of who learns about surveillance is a key one for the issue of who can obtain a remedy when surveillance is in violation of the Constitution or statutory law. And because very, very few people ever learn about foreign intelligence surveillance, it can be very, very difficult, if not impossible, to get a remedy. Now, notice isn't the only obstacle. There are standing hurdles and questions about what substantive remedies are available both to U.S. persons here in the U.S., but also from the European perspective, what causes of action could European rely on to vindicate a claim that surveillance was unlawful? So this is one pieces of that broader constellation of issues.
Patrick, that's very helpful. So in terms of the difficulties posed by the Schrems case, which requires judicial recourse and faults the U.S. for providing insufficient recourse, one proposal by Peter Swire, a very well-known privacy scholar in the U.S., has been to allow individual complaints either to the U.S. Privacy and Civil Liberties Oversight Board, the PCLOB, or to the civil liberties and privacy officers of relevant agencies in the intelligence community. And I think by that, Becky, Peter was talking about you. So can you discuss anything about how you think a private complaint system might work if you were one of the folks charged with fielding those private complaints?
Well, what I would say is that today people could submit a complaint to our office, and we, we'll look into those and go through that process. We get complaints coming through, although haven't found a credible one yet. There's an interesting set of emails that we receive and have to look at on a routine basis. And so some of those things, exist today. The questions of standing, I think, are hard. And none of these are easy answers. I think we've sort of gone through this a few times. This is sort of our third round of how to sort of bridge together two very different ways to think about privacy and what those requirements are. one of the things, though, that I do think as we talk about what does it mean to have intelligence services, I think talking about transparency and people understanding what it is our intelligence agencies do, how we go about our business, what are the existing privacy protections, is a really important place that, as the Europeans have kindly spent a lot of time inspecting what we are doing here in the US, because we have been extraordinarily transparent, we do not have that same level of transparency when we look at what some of the protections are there. And so in some ways it's interesting, because in addition to the Schrems 2 case that came down, Privacy International came down as well. And that is a equally sort of interesting legal case that we're seeing in Europe. And I think what we're starting to see here is, what do we think how do we think government institutions or different foreign governments should do what I'll call as spying? And there's been sort of a place where we've done these in different ways, and governments spy on one another, and there's actually benefit to that. There's benefit to sort of understanding some of that. So it's not that intelligence is necessarily bad. There are real benefits to doing that, and understanding and sort of coming forward and thinking about how are we going to bridge some of those differences and think about those things. And so I'll just say that as we have some of these conversations and we think about, what is the solution, and is it an American, it feels very much like America needs to change their laws. And I think instead we want to be thinking about, what is sort of the broader perspective here? And I'll just sort of circle back to say, we have in the US intelligence community really sort of learned our lessons post media leaks and tried to be much more transparent, tried to really be clear about how we're doing it. And we can each disagree about what it is, whether we think this is good or bad in terms of surveillance. But I think what we've really changed in the last 6 to 7 years is that there's actually facts on the ground, so that Patrick and I can have a legitimate argument back and forth about whether we think those decisions are right, as opposed to what I think previously had been not as much transparency in that space.
So Patrick, I want to give you an opportunity to respond to Becky on one point. Now, Becky, of course, works for the NSA. But in recent decisions of the Foreign Intelligence Surveillance Court, the FBI has been faulted for overly broad US person queries of this massive trove of 702 data. And that, I gather, is the subject of the Hasbajrami case. So can you tell us anything about what you think ought to happen before an agency like the FBI gets to pose a US person query?
Sure. So just to remind everyone, when we're talking about Section 702 queries, the way that we think about that program is that the government uses a set of extremely permissive criteria to intercept billions of emails and internet messages on US soil. And it does so on the theory that its targets are foreigners who don't have the benefit of Fourth Amendment rights. But in the course of that surveillance, many, many communications of Americans, which are protected by the Fourth Amendment, are swept up. And so the practice that kind of is the focus of your question, Peter, and of these many of these FISC opinions recently, is how the FBI especially, but also sometimes the NSA and the CIA, turn around and use those massive databases of emails and internet communications to investigate individual Americans. So the targets are foreigners. That's the justification for getting around the warrant requirement. But in many ways, Americans become the subject of investigations flowing out of that surveillance. And there's really a profound disconnect there between the rights that Americans have and the way that their emails are ultimately accessed and used. The government's bypassing the warrant requirement and is not providing anything resembling the protection of a warrant to the Americans who are swept up in that surveillance. And so the arguments that we've made in the Hasbajrami case and that we're making in a case that's coming up in the 10th Circuit in the Mutarov case is that the reasonableness under the Fourth Amendment requires that the government satisfy a similar burden when it sets its sights on Americans using those queries, that the government needs to obtain an individualized court order to preserve the type of protection that the Fourth Amendment affords to Americans, and that the current procedures, the minimization procedures, which are supposed to protect the privacy of not just Americans, but others, but especially Americans, need to be significantly strengthened to provide that type of individualized court approval.
So one of the concerns about surveillance abroad and also about new technologies like facial recognition has been that those technologies are biased, either intrinsically or because they use data sets to train algorithms that are compiled by humans. We know humans are biased, and that humans haven't taken sufficient care to cleanse the sets of the bias that is in there. So Margaret, do you want to talk briefly about the danger of bias in algorithms and other kinds of new technology?
Yeah, I think that it's such a critical issue, and without the benefit of something like the GDPR here in the United States, we don't have the same level of accountability, transparency, and fairness principles built into the way that we examine these algorithms. And so it's really unclear what the recourse would be for somebody who is, somebody who is adversely impacted or disparately impacted by bias within facial recognition technology, for example, which many empirical evidence resources has concluded has the type of bias that you've described, Peter. And so, as we embed these technologies more and more into law enforcement, and without pairing it with questions of what data is being used to build the algorithms, or who's designing it, or the impact of it, we do have, though, at the same time, consequences flowing from it. Who gets targeted, who gets selected, how is it being used as evidence in court? So you have a very high rate of, for example, false positives as being alleged, and yet if somebody has been identified as the suspect based on facial recognition technology, what kind of methods do they have to try to combat that? And I think that it's going to be very, very important for us to start to adopt both some type of remedial structure or anti-discrimination law or civil rights framework in order to address this, but also I think some additional transparency.
Very helpful. All right, so let me ask the panel now, do you have any further comments about some of the things that our fellow panelists have said?
Peter, I just wanted to mention that just building on Margaret's points, as well as Brian and others on some of these questions of artificial intelligence. The intelligence community has, I'll just say, equal concerns with some of the concerns. We don't want to find the wrong people. We want to make sure that those algorithms and things like that are working well. And to that end, over the summer, the ODNI, the Director of National Intelligence, issued our intelligence community principles for artificial intelligence, and really trying to think through both what are those overall principles for how we use and think about AI, and then what are some of the really practical things that we need folks who are developing these things to think about, and bringing up those exact conversations Margaret had, thinking about what are the data sets coming from, where are those exact biases there, and how do we make sure we're building for it? How are we making our systems, holistically looking at the issues associated with that, and just wanted to point that as a resource of some of the things we've been really thinking about in this space.
I think that's a very important point. And the website that Becky was talking about, the IC Intelligence Community on the Record website, is really a fount of information. It has a great deal of material, both opinions of the Foreign Intelligence Surveillance Court, other policy statements that Becky mentioned, all kinds of other materials, including the largely unredacted FISA request in the Carter Page case that I mentioned earlier. So it's an extraordinary resource. Frankly, I don't know of any other nation that has that kind of resource up when it comes to surveillance in the intelligence community. So maybe now we should go to questions from the audience. And I know that one question that a number of people in the audience have, and sort of alluded to already in our discussion, is the use of surveillance by other countries, including the People's Republic of China. particularly with respect to the Uyghur population of China, that is ethnic Turks who are Chinese nationals, many of whom are now interned, that is detained by the Chinese government. So does anyone want to talk about the surveillance regime in China and the dangers it poses to human rights? Seems to be an important issue.
I'm
So
happy to just say a word.
please, go ahead.
I'll just say quickly, and then Brian, you should go, that from the US perspective, we often look at what's happening in China as one of the possible paths that these technologies could take here. And certainly the human rights abuses that are reported from China are egregious and alarming. And there are the sets of questions that I think Brian touched on about how US companies are involved in exporting some of the technologies that are used there, and what responsibilities companies have ethically or legally to ensure that their tools are not used in ways that facilitate gross human rights abuses. But it's certainly a alarming model of how certain technologies can be integrated and put together in ways that track people and really both are used to facilitate additional human rights abuses and create a chilling effect for an entire society.
Brian, do you have thoughts about that?
Yeah, it's from a U.S. perspective, it's really interesting to see what leverage the U.S. government has to oppose what's going on in the Uyghur Autonomous Region of China, because this is an area that the current government has been quite vocal. Some people think it's convenient, it's tied to other goals related to China, but I think there's a genuine human rights concern. And they are trying to use a lot of different tools. They are using economic sanctions. They've imposed import bans on products coming from certain products coming from the region. They are working with the EU to get the EU to impose sanctions. And so but there are limits. There are limits that what one country can do in this circumstance. It's also an area where I think the power of the non-government community is pretty interesting here too. That I think they've had a lot to do with what U.S. Congress has done to focus their attention on these issues, to demand sanctions, to demand accountability for U.S. companies that are taking advantage of what's going on in the area. It's not just surveillance companies, but it's high-named retailers whose products are made from cotton produced in the region, for example, and other things. So it's an interesting case study to me, in the middle of a very tragic situation about what a country can do bilaterally, because that is our current approach is bilateral. What a country can do to stop a human rights abuse going on its own without kind of trying to take advantage of the traditional multilateral tools.
Other thoughts about go ahead.
Oh yeah, I wanted to chime in as well. I think that you can draw the parallel here with how countries cooperate in criminal matters. You cannot do any extradition or mutual legal assistance effort without checking how is this person going to be treated in a country, or how is the information that I'm sending to this country going to be treated, which basically allows you to say something about the compliance with the rule of law in a country. So in essence, you're basically using that kind of system to say something about what a country is doing. And I think if we draw some inspiration from that in also other sectors, that can actually help.
That's very helpful as well. So we also have a question now about a very timely issue in the US, which is foreign interference in our election. So the intelligence community has concluded that there was significant foreign interference, particularly on the part of Russia in the 2016 election. And of course, many people are concerned about a similar occurrence in this year's election. Becky, can you tell us anything about the intelligence community's concern about interference this time around?
We're working very closely with our partners at FBI and DHS to protect the elections. It's our number one, priority across the intelligence community. It is a whole of government approach. There's not any one. The biggest place I would say here is if you're able to vote, you should make sure you go out and vote. And really get out there, because that's going to be the best way to protect our democracy. But we've put out joint statements back a year ago talking about the work that we're doing there, and it's been a very well coordinated process associated with it.
Now, in 2016, the interference seemed to be sort of two orders. So one which involved interference with, or at least impersonation of sites on Facebook and other places. So dummies of various legitimate US sites. So for example, I guess there was a Tennessee GOP, that is Grand Old Party, a Republican site that turned out to have nothing to do with the actual Tennessee GOP, but turned out to be one of the most commonly referred to sites on election day in 2016. Then in addition, the other phase was foreign probing into our election infrastructure. That is the ways in which we actually count and tabulate ballots. So Becky and others, are both of those of concern this time around?
Well, I'll just offer that, voting is done very much at the very local level. And you can consider that both a feature and a bug. So what you see in one county isn't necessarily something you're going to see in another county. And so each of those has to be taken, sort of individually at that point. But I would say that, this is a whole of society activity. So it's not just the US government, it's what are our media doing? What are our social media doing? What are the platforms doing in that space? And there's been, I'll say, a number of different academic institutions really looking at those questions and thinking about how you build that resilience in. And, we participate in those, but we're not, certainly the federal government, much less the US intelligence community, is not the answer to those. Those are very much state, local resilience issues that are there. I'll just say again, make sure you go out and vote.
Other thoughts on that question? All right, let me pivot now to, or Margaret, did you have a thought on
Well, I
that?
was just going to say that I think that in the last 24, 48 hours with the email issue, with certain voters being targeted and having their sensitive information, their address, their real name, and then receiving this information, and according to media reports that it was a targeted campaign. I think it just demonstrates that there now seems to be a demonstrable link between the penetration of voter registration databases and this type of foreign interference, and that in the new type of cyber world that we live in now, and the cyber battlefield, that you have to really follow the road of the data and not just follow the money. Following the data and where that data leads to and how it can be exploited for geopolitical gain, I think is just a critical question.
And does the panel think that the naming and shaming of foreign sources, for example, through indictments of, let's say, people in the People's Republic of China, which we saw some years ago under the Obama administration, or more recently with Russia, is that a useful step, or is it just sort of a charade?
I actually think that we're here then talking about pretty much instrumentalizing criminal law. Because an indictment like the ones you mentioned, and there are several examples now already, they're never going to be executed because these people are never going to be extradited. Either there's no treaty or there will be an exception within the extradition treaty that will be used. So why are you making an indictment when you know it's never going to be realized, when you know these people are never going to be prosecuted? So what I've been thinking about quite a lot is there has to be a political message behind these indictments. There has to be a reason why these people are also on wanted posters in their uniforms. So there's more to it than just the indictment, because the indictment is never going to lead to a prosecution. So I see a political message in there.
And Brian, as someone who advised our State Department, do you think that's right, that there's a symbolic importance to indictments of that kind?
Yeah, I think that that is one of the goals, is with the law enforcement saying, we know what you're up to. We've identified specific people who are responsible or who are behind the action. And even if we can't extradite you or, find you in some way, we think it's important to put this out there in public that we've identified this activity. So I think that that's definitely been seen as the reason to do these things, which is different than your typical indictment, of course. And I think there's some value there. That from a State Department diplomacy perspective, some of these raise issues about immunity of foreign officials and can we actually go after them even if we do arrest them. That's kind of a different topic. But I think there's good reason to use this type of a vehicle judiciously, at least.
Another question about the procedure followed in FISA cases. So at the moment, the FISA court has both inherent and statutory authority to appoint amici, that is friends of the court, who offer a perspective on legal, factual, and sometimes technical issues that's different from the perspective of the government. And technical amici actually were used in a recent case, very interesting case by the FISC on sort of multiple facilities and the possibility of conducting surveillance on multiple facilities. I view that as a case about social media, but I'll leave what it's about to another time. But do people think that that recourse is useful to some voice other than the government? And should we institutionalize that further, as some people have urged, for example, through a formation of a public advocate's office that will take up another perspective on an ongoing basis?
I'm happy to start off on that, Peter. I know this is something you've been thinking a lot about and writing about recently, and there certainly has been a push for a number of years now, but especially after the Carter Page disclosures, for a more prominent or expansive role for amici or a public advocate on the court or in court, those FISC proceedings, to bring a different perspective, either on the civil liberties and privacy issues, or on the technical issues, just like you highlighted from the recent opinion. And so there are proposals on the table, including one from Senators Leahy and Lee, that would expand the availability or the requirement that the FISA court appoint an amicus in certain types of sensitive cases. And there's the possibility that the Congress will take up those reform efforts, presumably after the election at this point. So I think that's an area that we're likely to see continuing debate around, and certainly support the addition of those perspectives to the FISA court's proceedings.
Other folks want to weigh in on that? And how about human rights law generally? So we of course have guaranteed privacy under human rights, including the International Covenant of Civil and Political Rights. Should we have an express right to data protection under international human rights law? Els, do you want to weigh in on that?
Yes, I think so far the EU is still the only region that has that. In fact, since the Lisbon Treaty, we've written it into our charter. I think there is some merit to having that, because you end up giving data subjects more tools into their hands to argue certain cases. The case that I typically use to explain the difference between privacy and data protection and the merit of having both rights independent of each other to my students is the Cambridge Analytica Facebook case, which I think would be quite hard to argue based on the right to privacy as it is defined in the EU, but would be easier to argue based on the right to data protection. Because this was, as far as we know, a clear violation of purpose limitation principle, because people consented to some use of their data, but not to the use that was eventually made of it. So I think in those kind of cases, having an independent right to data protection to invoke, that is really a better protection for data subjects.
Anyone else want to weigh in?
I wanted to say that, especially during this time of pandemic surveillance and COVID-19 data tracking technologies and digital contact tracing, that the fact that the United States does not have something like the GDPR that the EU does, and I think that really gives that sharp contrast on why it would be beneficial to have a uniform data protection, not only legal regime, but to have it framed within a human rights, I think, concept, which we also do not have in the United States. But I think that it would be extremely helpful in light of the fact that all of these technologies are being introduced with varying state laws that will impact the data protection, data privacy issues, and yet no uniform, comprehensive federal law.
Right. Brian.
Two fingers on that, Peter. We live with the system that we have in a way. And so the idea that we will have new multilateral human rights treaties in the near term is a low probability. And the same with federal legislation. It's been tried and not successful multiple times. But it's interesting to see how some of these states are really encouraging, because companies have to deal with 50 states, particularly data companies. When you look at what Illinois and California are starting to do, you kind of wonder if that's going to lead to something that's more akin to the national standard that Margaret was just talking about.
Excellent point. Well, on that note, I'll do is wrap it up. Thank you so much to panelists and to our audience for excellent questions. Thank you. And we hope to see you next year, hopefully next year in person. Thanks again.